300%.
Yeah.
That is the number that honestly just stopped me in my tracks this morning. According to the Australian Psychological Society, that is how much ADHD diagnoses have shot up in the decade leading to 2023.
It's a staggering figure, isn't it? We're talking about roughly 1 in 20 Australians now having the condition.
1 in 20.
It's a massive shift in, the makeup of our workplaces, our society.
Which means if you are in an office, on a construction site, wherever, the odds are very high that you are working right next to someone with a neurodivergent brain. And that gets us to the core tension we're diving into today. Because you've got this huge change in the population crashing headfirst into the immovable object of traditional workplace rules.
The old way of doing things.
Exactly.
Yeah.
You know the drill, sit still, be on time, follow the process exactly as it's written.
And that collision is getting messy. The big question we're trying to get to the bottom of is, it's a legal one, but it's also deeply human. When does firing someone for what looks like bad behavior actually cross the line into discrimination against a disability?
Because that line is a lot blurrier than most people realize.
A lot blurrier. For managers and, to be honest, for employees too.
So to find that line, we're digging into some case studies provided by the Australian Workplace Discrimination Representatives, or AWDR.
Right. These are the folks who get involved when things go sideways.
And we should probably clarify something right up front. We're looking at this through an Australian lens, but the actual cases we're dissecting, they're from UK tribunals.
Which is a really important point. Australian and UK employment law, they share a lot of the same DNA. And UK tribunals often set the tone globally for how these disputes are viewed.
So they set precedents.
They do. They provide the case law, the stories, really, that help Australian courts and commissions decide what's fair. So even if the accents in the original transcripts are British, the lessons are absolutely applicable here.
Got it. Okay, so we have 3 of these stories to get through. We've got an employee who was labeled disorganized, one who committed a pretty serious safety breach,
A very serious one.
and one who, well, it involves a sandwich and some very, very bad decisions.
The sandwich incident is memorable. We'll get to that one.
Okay, let's start with the first case. This is the story of Nicole Hogger, and on paper, she sounds like a star employee.
Absolutely. She started at a PR firm, Genesis PR, back in 2018, was a high performer, got promoted to account manager. She was, by all accounts, crushing it.
But then what happened?
In 2020, she received an ADHD diagnosis. And this is a pattern we see all the time in this space. A high performer gets promoted, the workload increases, the demand on their executive function gets higher.
And the old coping mechanisms just don't work anymore.
They just collapse. And for her, that collapse looked like going dark. That was the term used.
Going dark.
Right. When she got overwhelmed, she wouldn't ask for help. She'd just shut down. Missed client deadlines, stopped responding to emails. And it all came to a head in June 2023 when she just went completely AWOL during work hours.
Okay, I have to play skeptic for a second here.
Sure.
Because when they finally got a hold of her, she admitted she wasn't working from home. She'd gone for a massage. She went to Starbucks. The supermarket. I mean, if I'm her manager, I'm not thinking disability. I'm thinking time theft.
And 99% of managers would agree with you. Genesis PR certainly did. They put her straight onto a performance improvement plan.
As you would?
But this is where the legal ground starts to shift under their feet. During that meeting, a manager told Nicole that her behavior, the lateness, missing things, would lead her colleagues to see her as disorganized.
She was being disorganized. I mean, she was at a spa while clients were waiting. How is that not just a factual description of what was happening?
That was their exact argument. They said, we're just stating facts. But Nicole resigned and then sued them for constructive dismissal.
Okay, let's pause on that term, constructive dismissal. What does that actually mean?
It's a crucial idea. It basically means the company didn't technically fire you, but they made the work environment so hostile, so impossible, that you were forced to quit.
So the law treats your resignation as if it were a firing.
Exactly. Because you had no other real choice.
And her argument was that being called disorganized created that hostile environment.
Yes. She argued that because she had already told them about her ADHD, and because disorganization is a core symptom of it, using that specific label wasn't helpful feedback. It was harassment. It undermined her dignity.
Wow. And the tribunal actually bought that.
They did. They ruled in her favor. And the logic they use is fascinating.
Go on.
The tribunal said there was, and I'm quoting here, little, if anything, Nicole could have done with the feedback, you were disorganized. It's like telling a person in a wheelchair, you're not using the stairs very well.
It's true, but it's useless. And it just points out the disability without solving the problem.
Precisely. The employer has to provide a solution, or at least try to. They failed to make reasonable adjustments. They focused on the person as a character flaw instead of the structural support she needed.
So the whole massage and Starbucks thing, that didn't end up mattering as much?
It mattered, but it didn't cancel out the discrimination. The employer's failure to support her before it got to that point was the key.
So the takeaway is, labeling a symptom isn't managing, it's potentially harassment.
That's it. And that's a huge mental shift for most managers.
That is going to make a few people in HR offices sweat a little bit. Puts the onus right back on the leadership.
It does. And if that's making you sweat, let's move to our second case, because this one gets even more nuanced. This is all about the process of firing itself.
Okay.
We're looking at a man named Ryan Hill, a deputy store manager at Lidl.
Right. Ryan was diagnosed with ADHD in 2022, and his case file introduces a couple of terms I think we need to quickly unpack. Rejection sensitive dysphoria, or RSD, and ADHD paralysis.
These are huge, and they're so often misunderstood. Let's start with ADHD paralysis.
I think people hear paralysis and just think lazy.
Right, like you're just procrastinating. But it's a neurological state. The brain is so overwhelmed by choice or information that it literally cannot initiate a task. It's a freeze response.
And RSD?
Rejection sensitive dysphoria. It's an extreme emotional sensitivity to perceived criticism or rejection. For someone with RSD, a slightly negative comment from a boss can feel like actual physical pain.
And it triggers this massive defensive reaction.
Or a total shutdown.
Yeah.
So Ryan is dealing with both of these. He asks his manager for a schedule change, no shifts after 6 p.m., to help him manage his routine.
Which is a pretty common request for ADHD management.
Very common. But the manager's response was not great. She told him, there is no such thing as a morning manager, and then suggested he consider his position.
Which would be a massive trigger for the RSD.
Huge. But that's not actually why he was fired. He got fired because, after transferring to a new store, he operated a powered pallet truck without having his official authorization.
Okay. Again, putting on the employer hat. That's heavy machinery, no license, huge safety risk. That sounds like textbook gross misconduct.
It is. You're absolutely right. And the tribunal agreed that they did not dispute the safety breach. They said operating that truck was gross misconduct.
But I feel a but coming. He won the case anyway.
He did. And this is the key takeaway for this part of our deep dive. You can have a perfectly valid reason to fire someone, but if your process for firing them is discriminatory, the whole dismissal can be overturned.
How was the process discriminatory?
It comes back to that ADHD paralysis and RSD. During the disciplinary meetings, Lidl's managers said Ryan was being defiant. They said he showed a lack of remorse.
Why? Because he wasn't engaging.
Yes. He was shutting down, giving one-word answers, or just going silent when asked long, formal questions.
But from his perspective, he wasn't being defiant. He was overwhelmed. He was freezing.
That is exactly what the tribunal found. He was struggling to process complex sentences in a high-stress environment. What Lidl saw as a bad attitude, the tribunal saw as a disability symptom in real time.
So the investigation itself was flawed because it wasn't designed for his brain to be able to participate fairly.
Spot on. The tribunal ruled that procedural fairness means you have to accommodate the disability during the hearing. Ryan needed breaks. He needed shorter, clearer questions. He needed time to process.
By not giving him that, they put him at what was the term?
A substantial disadvantage.
That's mind-blowing. It's not enough to be right about what they did wrong. You have to be fair in how you even talk to them about it.
It raises a really tricky question for managers, doesn't it? Is your employee being insubordinate, or are they neurologically unable to process what you're saying right now? If you can't tell the difference, you are in a legal minefield.
Okay, so Nicole wins on labeling, Ryan wins on process. It's starting to feel like an ADHD diagnosis is a get-out-of-jail-free card, but I'm guessing our third case shows us the limit.
There's a very hard limit, and that brings us to Brooklyn Forrester Hayes.
Brooklyn was an apprentice at a truck depot. He was diagnosed very young, at age 5, but he'd been unmedicated since he was a teenager. And the culture at this place sounds rough.
It was a very strong banter culture, practical jokes, hazing. The tension was already high before the main incident.
Right, but the thing that got him fired, I mean, I have to say, I feel for him on this one. He goes to eat his lunch and finds someone has poked holes in his sandwiches and scattered tea leaves all over his food.
It's not banter, it's bullying. It's designed to humiliate.
So Brooklyn snaps. But he doesn't just yell this time.
No. He goes on Snapchat, and over a period of time, He sends aggressive, violent threats to multiple colleagues.
And his defense was basically the same as the others. I have ADHD, I have poor impulse control, you provoked me, and my disability is why I reacted this way.
Yeah, here's the real twist. The tribunal agreed with the cause. They accepted that his ADHD contributed to the impulsive behavior. They saw the link.
But he still lost his case, so why was this one different?
Because of the duty of care. The tribunal basically said an explanation is not an excuse. An employer has an overriding legal duty to keep all of their staff safe from threats of violence.
So safety trumps the disability accommodation.
Always. The tribunal looked at the severity of the threats. The medium using Snapchat showed it wasn't just a heat-of-the-moment shout. It required steps and the duration. He kept doing it.
So the takeaway here is you can be neurodivergent, you can even be provoked, but if you make other employees fear for their physical safety, the employer has a right and a duty to remove you.
Correct. The law protects the disability, but it doesn't require an employer to tolerate genuine threats. Physical safety sits at the top of the hierarchy of rights in the workplace.
It's a tragic case, though, because that workplace culture really failed him first.
It absolutely did. But his reaction broke the social contract in a way that couldn't be fixed by a reasonable adjustment.
So we've broken down these cases. Let's zoom out for a second. If you're listening to this, maybe you've just been fired and you're thinking, I can't afford a lawyer to fight this.
Yeah, it's incredibly daunting. And that's why the source material highlights organizations like ADBUDR, the Australian Workplace Discrimination Representatives. And it's important to know they aren't a law firm. They're workplace relations specialists.
What's the practical difference for someone listening?
They focus specifically on the fair work system mediation, conciliation. Their job is to level the playing field, so it's not just one stressed-out person against a massive corporate HR department.
And they often use a no-win, no-fee model, which is a huge deal. But there's one detail in their notes that just jumped out at me: the timeline.
It is the single most important piece of practical advice in this entire deep dive.
Okay, what is it?
If you believe you have been unfairly dismissed in Australia, you have exactly 21 days to lodge a claim.
3 weeks. That's it.
That's it.
That is nothing. You're still in shock. You're dealing with that RSD we just talked about.
It's a brutal deadline. So many people wait a month to cool off or get their head straight, and by the time they decide to act, they've legally forfeited their right to do anything about it.
Yeah. Wow. So the message is, do not wait. If you think something is wrong, you have to move immediately.
Immediately.
Okay, so let's wrap this all up. We've got Nicole, Ryan, and Brooklyn. If we boil this all down to the absolute essentials, what are they?
I think there are 3 really clear pillars. First, from Nicole. Labels require solutions. You can't just punish a symptom. If you identify a problem linked to a disability, you have to offer a way to help.
Got it. Second, from Ryan, the process matters. You can't conduct a fair dismissal if your investigation process is inaccessible to the person's brain.
Exactly. And third, from Brooklyn. Disability has a limit. And that limit is the safety of other people. An explanation for your behavior is not a shield from the consequences of making threats.
It really feels like we're at a turning point moving past just allowing neurodiversity in the workplace.
I think we are. We have to be. We're entering an era where we have to translate it. The workplace of the future isn't just about building wheelchair ramps. It's about building cognitive ramps.
Cognitive ramps. I like that.
If a manager still interprets someone needing extra time to process as defiance, then that manager is the one who's obsolete, not the employee. We have to stop seeing different operating systems as just broken versions of the standard one.
And building those ramps, like clearer instructions or allowing breaks in tense meetings, that helps everyone.
It makes the workplace better for everybody, neurodivergent or not. Who doesn't want that?
A really powerful way to look at it. Thank you for breaking all this down.
My pleasure.
And for you listening, maybe take a look at your own team tomorrow with fresh eyes. You never really know what's going on under the surface. We'll catch you in the next deep dive.